Understanding everyday risk in real estate practice. In the previous sections of this chapter, you learned that risk is unavoidable and that the safest licensees are not the ones who never face risk, but the ones who manage it deliberately. You explored 4 big strategies for managing risk: avoidance, reduction, transference, and retention, and then looked at practical office procedures such as education, documentation, record keeping, standard forms, and insurance. In this section, you connect those strategies to the real world. Instead of talking about risk in the abstract, you will walk through the primary areas in which risk shows up in everyday practice: agency, disclosures, advertising, contracts, money handling, fair housing, antitrust, RESPA, and more. You will see how one careless comment, one missing form, or one casual, "oh, it's fine," can become a lawsuit, a complaint with the real estate commission, or a damaged reputation. By the end of this section, you should be able to explain the main categories of risk in real estate brokerage, recognize how they show up in ordinary transactions, and apply concrete risk management tools to reduce your exposure. You should also be able to connect these risks back to the duties you owe under agency law, fair housing law, license law, and professional ethics. Agency risk, duties, disclosures, and status agency is the foundation of most of your relationships in real estate. When you represent a buyer, seller, landlord, or tenant, you are not just helping them with a deal. You are taking on legal duties defined by statute, common law, and your brokerage policy. 2 big categories of risk flow out of agency: the duty to inform and disclose, and the duty to carry out your agency obligations properly. A licensee may act as a facilitator, single agent, dual agent, designated agent, sub-agent, or non-agent, depending on state law and brokerage policy. Regardless of the label, you must follow your state's disclosure requirements. These typically require you to clearly disclose your status in 3 stages. First, you disclose your role verbally to other licensees at initial contact. Second, you disclose verbally to the buyer and seller before you begin providing substantive real estate services. Third, you confirm your status in writing before signatures go on a listing agreement, before presenting offers to an unrepresented seller, or before preparing an offer for an unrepresented buyer. Written acknowledgement from the consumer is your proof later that you complied. Agency also brings other disclosure duties. You must disclose if you have a personal interest in the transaction, such as being the owner or buyer. You must disclose if you will receive a personal benefit from a referral, such as a marketing fee from a home warranty company. You must disclose required property and market information, and you must disclose information about customers that your client is entitled to know, such as the fact that a buyer is unrepresented. Beyond disclosure of status, you owe basic duties to everyone and enhanced duties to your clients. To all parties, you owe honesty, fairness, reasonable care, and skill, and required disclosures. To your clients, you owe skill, care, diligence, loyalty, obedience to lawful instructions, confidentiality, accounting for funds, and full disclosure of material facts. These duties sound simple, but they generate daily risk. If you are casual or negligent, you may breach your duty of skill and care. If you put your own commission ahead of your client's interests, you may breach your duty of loyalty. If you follow your client's instructions when they are illegal or discriminatory, you may violate fair housing law or license law, even if you think you were just doing what they wanted. Consider 2 quick examples. First, a listing agent knows the roof has leaked in heavy storms, but convinces the seller not to mention it and keeps it off the disclosure form. When the buyer later discovers damage, they sue both the seller and the agent for misrepresentation and breach of duty. Second, a buyer's agent learns privately that their buyer can pay significantly more, but shares that information with the listing agent to get the deal done. If the buyer later discovers this, they may claim a breach of confidentiality and loyalty. Conflicts of interest. Conflicts of interest occur when an agent's personal interests, or the interests of another client, collide with the duty to put a current client's interests first. These can arise in many ways: undisclosed dual agency, broker-owned listings, agents buying properties for themselves, steering business to favored vendors, or allowing property management side deals to influence advice. Even everyday transactions contain built-in conflict risk. In most residential deals, you do not get paid unless the transaction closes. That creates a subtle pressure to keep the deal alive, even when it might not be in your client's best interest. For example, if a home inspection reveals serious structural problems, the best option for the buyer may be to terminate. A conflicted agent might downplay the issues to preserve their commission. Risk management starts with awareness and transparency. Disclose any self-interest you have in the property or transaction. If you are buying or selling for yourself or a family member, disclose in writing. If you have a financial relationship with a home inspector, lender, or contractor you recommend, disclose that relationship. When in doubt, disclose and document. Confidentiality and protection of personal information. Confidentiality is a core agency duty that continues even after a transaction closes or an agency agreement ends. Confidential information generally includes a client's motivations, financial position, personal details, and any information the client specifically designates as confidential. It does not usually include information in public records or information the client shares publicly with others. For example, if your seller tells you they are divorcing and must sell quickly, that information, if revealed, could harm their bargaining position. You should not reveal it without written permission. If your buyer tells you they can go up to a certain price, you must not share that maximum with the seller or listing agent. Modern risk management also includes data security. Many states require businesses to provide reasonable security for the personal information they collect. That means protecting client files, shredding or securely deleting documents you no longer need, guarding passwords, and being careful what you send over unsecured email or text. Failing to protect personal information can create legal liability in addition to harming your reputation. Penalties for agency and disclosure violations. Breach of agency duties or failure to make required disclosures can lead to serious consequences. A court may rescind the transaction, undoing the sale, and forcing parties to unwind the deal. You can lose your right to commission. You might be responsible for fees and costs, including the other side's attorney's fees if a statute allows it. Courts can award punitive damages in serious cases. Professional organizations may impose ethics discipline, and the Real Estate Commission can suspend, condition, or revoke your license. Remember that even if you ultimately win a lawsuit or complaint, you still lose time, energy, and reputation. Solid documentation, clear disclosures, and consistent compliance with brokerage policy are your best protection. Property disclosure risk, condition and hazards. Property condition disclosure is a major risk area. Most states require sellers of residential property to deliver a written property disclosure or disclaimer before a purchase contract is accepted. This form generally covers known material defects in the structure, systems, and land. A second disclosure or update may be required at closing if conditions have changed. As a licensee, you must make sure disclosures are delivered on time and that buyers acknowledge receipt. Even when your state allows sellers to disclaim, you may still face liability if you deliberately distort facts, conceal known defects, or repeat information you should have known was false. Intentional misrepresentation and fraud are obvious dangers, but even unintentional misrepresentation can be a problem if your statements go beyond your competence or contradict what a reasonable licensee should have discovered. Federal law creates additional disclosure obligations for certain hazards. The best known example is lead-based paint in housing built before 1978. In those cases, the seller must provide a lead-based paint disclosure and any known reports or records. and the buyer must receive the required pamphlet and opportunity to conduct a lead-based paint inspection. Errors, missing signatures, or incorrect dates on these forms can trigger significant fines and allow buyers to claim treble damages. Other local or state laws may require disclosures about wood infestation, septic systems, soil conditions, radon, mold, or impact fees. Your job is to know what is required in your jurisdiction, to use the correct forms, and to make sure they are fully and accurately completed and delivered. Listing and selling risk, agreements, pricing, and communication. The listing and selling process is where many day-to-day risks arise. The starting point is the listing agreement. In most states, this agreement must be in writing to be enforceable and must contain a definite termination date. Net listings are often prohibited because they invite abuse and conflict of interest. An agent has a duty of due diligence in verifying key facts: the property condition, the ownership status, and the owner's authority to act. Taking a listing without confirming that your seller actually holds title, or without spotting obvious physical issues, can leave you exposed when the buyer later claims that you misrepresented the property. Estimating value is another risk point. When preparing a comparative market analysis, avoid using the word appraisal or stating that you are determining value in the same way a licensed appraiser would. Use terms such as recommended listing price or recommended price range. Be conservative, document your method, and maintain evidence that the seller chose the final price. If the property later fails to appraise at contract price, you will have a record showing you did not push the property far beyond market indicators. Estimates of closing costs can also create risk. If you prepare net sheets or buyer cost estimates, make it clear that they are estimates, not guarantees. Use standard brokerage forms if available, and encourage consumers to review figures with the lender, title company, or escrow agent. If you omit major items such as association transfer fees, prorated taxes, or lender fees, your client may blame you for unpleasant surprises at closing. Throughout the listing and selling process, your communication record is your shield. Confirm key conversations by email, create transaction checklists, and save documentation. If there is a later dispute about whether you advised a seller about pricing or inspection options, your written notes may be the difference between a quick resolution and a costly complaint. Advertising and permissions risk. Advertising touches nearly every aspect of your business: yard signs, mailers, websites, social media posts, and online profiles. State and federal laws regulate advertising content, especially when it overlaps with fair housing and license law. Risk arises when advertising is misleading, incomplete, discriminatory, or inconsistent with brokerage policy. Common violations include making substantial and intentional misrepresentations about a property, making promises that you cannot or will not keep, or using titles and trade names you are not entitled to use. Advertising yourself as a realtor when you are not an active member of the association, or using another organization's logo without membership or authorization can lead to discipline. Advertising a property that is no longer on the market or implying that you sold something you did not sell can also create trouble. You must also stay within your authority. Unless your listing agreement gives you explicit permission, you should obtain written consent before posting signs. Using photos in marketing, placing a lockbox on the property, sharing the listing with the MLS, or appointing subagents or designated agents. If you change the agency status during the relationship, such as moving from single agency to a dual or limited role, you must obtain new written consent. Scope of expertise and unauthorized practice of law clients often want you to be much more than a real estate professional. They may ask for tax advice, legal opinions, structural opinions, environmental evaluations, or predictions about future zoning changes. If you step into roles you are not licensed or trained to fill, you increase your risk dramatically. Real estate licensees are not attorneys, appraisers, engineers, or inspectors. You may fill in blanks on approved contract forms, explain what standard clauses generally mean in plain language, and help parties understand the process. But drafting new legal language, interpreting unfamiliar contract clauses, or advising a client not to seek legal counsel can cross the line into the unauthorized practice of law. Risk management here centers on honest disclosure of your limits and the use of referrals. If a legal or technical question arises, say directly that you are not an attorney or specialist and recommend that the client consult a qualified professional. Use phrases such as, "in my non-legal opinion," and always encourage written advice from attorneys, accountants, engineers, and inspectors. Document these referrals. Contracting, risk, forms, contingencies, and accuracy. All contracts for the sale or transfer of real estate must be in writing to be enforceable. That fact alone makes your contract work a critical risk area. Poorly prepared or incomplete contracts can lead to disputes, failed closings, and lawsuits. Common contract risks include using illegal or outdated forms, failing to include clear termination dates, and failing to list what is included or excluded from the sale. For example, if a seller intends to keep a favorite chandelier, but the contract does not exclude it, the buyer may reasonably expect it to convey. Similarly, if you fail to track contingency deadlines for inspections, financing, or appraisals, the contract can lapse, or one party may lose important rights. Accuracy is essential. Dates, legal names, purchase prices, financing terms, legal descriptions, and contingency language must match what the parties have actually agreed upon. A simple mistake in a legal description can leave a buyer without full title to the intended property. Misstated financing terms may violate lender guidelines or RESPA. A time is of the essence clause
Heightens the importance of every date in the contract, making missed deadlines especially dangerous.
to manage risk. Use current, approved forms. Review them carefully, and use checklists to ensure you address all necessary provisions. Encourage parties to seek legal review if there is anything unusual or complex. Misrepresentation risk. Unintentional and intentional. Misrepresentation means conveying false or misleading information. It may be unintentional or intentional. Unintentional misrepresentation occurs when you unknowingly provide inaccurate information that, as a professional, you should have known was wrong. This often happens in describing property sizes, using outdated public records, or casually stating that a neighborhood is safe or perfect for investment without a reasonable basis. Intentional misrepresentation, or fraud, occurs when you know the information you provide is false but give it anyway. Fraud is not only a license issue, it is a crime that can lead to fines and incarceration. For example, knowingly hiding foundation cracks or falsifying multiple offers to create artificial bidding pressure can be considered fraud. You can reduce misrepresentation risk by learning to measure accurately, avoiding exaggeration, using cautious language when discussing future changes, and verifying information wherever possible. When in doubt, disclose what you know, avoid guessing, and suggest that the buyer obtain their own expert evaluation. Recommending providers and third-party risk. Clients frequently ask for recommendations. Inspectors, lenders, contractors, property managers, attorneys, and more. Recommending providers creates several layers of risk. If the provider performs poorly, the client may blame you. If the provider engages in illegal practices, you may be drawn into the dispute. If you have a financial or ownership interest in the provider and fail to disclose it, you may violate both license law and RESPA. To manage this risk, shift decision-making back to the client while still being helpful. You can decline to recommend anyone and suggest that the client research providers independently. Or you can provide a list of several qualified providers and state clearly that the client is free to choose any provider they wish, on or off your list. If you have a business relationship with anyone on the list, disclose it in writing. Remind clients that they are responsible for investigating providers and making the final choice. Fair housing risk. Fair housing risks show up in advertising, steering, screening, and everyday conversations. The safest approach is to treat all prospective clients and customers equally, and to focus your comments on the property and the process, not on the characteristics of people or neighborhoods. In advertising, avoid words or phrases that suggest preference or limitation based on protected characteristics such as race, color, religion, national origin, sex, disability, or familial status. Instead of saying perfect for young couples or no kids, describe the property's features: 3 bedrooms, a fenced yard, a home office, or proximity to parks and schools. Use neutral location descriptions like the street name or subdivision rather than references that imply who belongs there. When answering questions, you may occasionally be asked about crime, schools, or what kind of people live in an area. Do not answer in a way that favors or disfavors any protected class. Instead, explain that you cannot legally discuss those topics and refer the consumer to police crime maps, school rating sites, or demographic data sources so they can make their own judgments. Before listing a property, explain to the seller that you must comply with fair housing laws and cannot follow discriminatory instructions. Make it clear that you will not limit showings or offers based on protected characteristics. If a seller insists on discrimination, you must terminate the relationship rather than participate in illegal conduct. Antitrust risk. Antitrust laws aim to protect competition and prevent practices that harm consumers, such as price fixing and market allocation. In real estate brokerage, the most common danger is commission discussions among competitors. If brokers agree, or appear to agree, on a standard commission rate or how clients will be treated, they may face antitrust charges. You must never state or imply that your commission rate is the standard, or that the board will not allow lower or higher fees. Your commission is set by your brokerage and is negotiable between you and your client. Avoid discussing commission structures or splits with agents from competing firms, except as necessary to negotiate a particular cooperative transaction. Antitrust risk can lead to severe penalties, including fines, damages multiplied by 3, and potential criminal consequences. Your safest practice is to emphasize that your fees are independently determined and negotiable, and to walk away from any group discussion that veers into fee setting or market division. Rules, regulations, and license discipline. State real estate statutes and commission rules exist largely to protect the public, but they also serve as a roadmap for staying out of trouble. Non-compliance can result in license expiration, suspension, revocation, civil penalties, and lawsuits. Licenses may expire if you fail to complete required continuing education, maintain required insurance, or renew properly. More serious violations, such as obtaining a license under false pretenses, mishandling trust funds, or failing to present all written offers, can lead to suspension or revocation. Licensees are often disciplined for acting with an expired license, paying or receiving illegal referral fees, entering prohibited net listings, or interfering with existing agency relationships. They may also be disciplined or sued for fair housing violations, antitrust violations, agency breaches, unauthorized practice of law, failures to disclose, fraud, or theft. The best protection is simple but demanding. Know your statutes and rules, follow brokerage policy, document your actions, and ask for guidance when you are unsure. Financing, appraisal, RSP, and closing risk. The financing and closing stages are dense with disclosures, timelines, and third-party actions that you do not control, but that can still create risk for you. Buyers may feel misled if they are surprised by loan fees, escrow requirements, or appraisal results. Sellers may feel misinformed if they did not understand how taxes, commissions, or payoff amounts would affect their bottom line. You should be prepared to explain the basics of lending fees, points, origination costs, prepaid interest, escrows, and typical closing costs, while still emphasizing that the lender and title company provide final figures. Help your clients compare loans by looking at the total cost, not simply the note rate. Encourage them to read the loan estimate and closing disclosure thoroughly and to ask questions directly of the lender. Appraisal issues are common. If an appraisal comes in low, the buyer may need to bring in more cash, or the seller may need to lower the price. If an appraisal comes in much higher than the purchase price, the seller may feel that they underpriced the property. You can protect yourself by documenting your comparative market analysis, noting that the seller chose the listing or contract price, and reminding parties that appraisals are opinions based on specific guidelines and recent data, not guarantees of future value. RESPA governs many aspects of settlement for federally related mortgage loans. It requires that borrowers receive certain disclosures about settlement costs and prohibits kickbacks for settlement service referrals. As a licensee, your main risks under RESPA are failing to ensure that consumers are informed of their rights and participating in illegal referral arrangements. Avoid accepting or giving anything of value in exchange for referrals to settlement service providers, such as title companies, lenders, or inspectors, unless allowed by law and fully disclosed. Co-brokerage commission sharing among licensed brokers is generally permitted, but referral fees from unlicensed settlement service providers are not.